Hi small business owners, it's Western Singh from Western Law Firm. So while we are progressing on this series of video about commercial real estate transaction, today I want to talk about the topic of how to hold title as while you're progressing, and probably at the end, if not in the beginning, you have to decide, and probably the escrow officer will ask you, okay, how you like to hold the title. And this question mostly comes in when you have multiple owners. You can hold the title under the name of an entity, either under an LLC or a corporation, and there are advantages for that. But usually people hold real estate title under their individual name, either maybe because I think it's much more simple, you don't have to do anything special. Otherwise, for LLC, you have to just file documents with the state and wait for, probably even if you do an expedited filing, maybe a week or so. So it's simple just to put the name on the title and you don't have to do anything. So if you are multiple people thinking to own the title, then you have to think about different option how to hold the title when you are a co-owner. So there are two big options. One is tenants in common and another is joint tenancy with right of survivorship. Usually it's called joint tenancy. So let me go through one by one. So one is the tenants in common, which is a default way to hold title among co-owners. So what it is, just don't get confused when I am saying you tenants in common. It's not a lease I'm talking about. It's actually an ownership relation you have with the other co-owner. So this is basically a very simple way of owning the land, and it provides that any co-owner can have any kind of percentage share of the ownership, regardless of how much they have put the down payment. You can figure out among yourself, but the default is 50-50. And sure, if you went into the litigation and then other side talks about how much percentage, but just to keep the thing simple, so 50-50 usually people own if you are two co-owners. So owning the land in 50-50 split doesn't mean that you physically own the land 50-50. That's just your share of ownership. So each and every single co-owner have complete access to the whole land, and they can enjoy the ownership on the whole land. So usually there can be issue, maybe your co-owner maybe is not allowing you to enter the other property. Maybe he is thinking about, I own 70% and you own 30, so why not you just keep 30 on the side? That it doesn't work like that. So each and every co-owner, if even the co-owner who have 1% have complete access to the whole property under which you have this co-owner relationship. So that's one of the thing, and how you create a tenancy in common way of owning the land. It's basically you don't have to do anything. If you put bunch of names on the deed and don't mention anything about how you want to own the land, it's basically by default you own the land under tenant in common kind of co-ownership. So in tenant in common, so the main advantage is it's simple. You don't have to put any special language in it, and you just basically are owning the land based on whatever percentage you want, and you have the complete access, and also you can enjoy the property completely.